Hello, everyone, and welcome to today's webinar, Are Your Employees Still Exempt? A review of the DOL's 2024 final FLSA overtime regulation. Today's webinar is being recorded, and you'll receive a follow-up email within 24 to 48 hours with a link to view the recording and a copy of the slides. You will have the opportunity to submit text questions to today's presenter by typing your questions into the questions pane of the control panel. You may send in your questions at any time during the presentation. We will collect these and address them at the end of the presentation. Today's presenter is Betsy Davis, partner and co-chair of our Labor and Employment section at Whiteford. I'll now turn it over to Betsy.
Elena, thank you for the introduction, and thanks to all of you for joining us today to talk about the changes in the Fair Labor Standards Act. I'm happy to see a number of our Whiteford clients that I work with regularly and many new folks who have joined us for this webinar. I hope to have an opportunity to meet and work with each of you in the near future. The recent changes in the FLSA exemption test certainly is an issue impacting nearly every employer. And the changes have begun and are scheduled to continue to change over the next several years. So let's start by taking a quick look at what we're going to talk about today. First, we will review the foundation of the Fair Labor Standards Act and what it means to be an exempt employee. We're going to talk about the changes, but some things have stayed the same. And so it's important for us to review the basic principles of the Fair Labor Standards exemption status. Next, we will compare the prior and the new Department of Labor salary threshold test. Then, let's discuss key takeaways for employers. That's what you really want to know. What should you do to comply and get ready for future compliance obligations? Finally, I will share with you some of the current litigation information that involves the new rule and my best sense of what the future may hold. So let's move on and begin. Let's start with the Fair Labor Standards Act exemption employee status. So to review, and you all probably already have this information, the FLSA is a federal law that establishes minimum wage and overtime pay for non-exempt employees. And we're going to talk a lot about what it means to be non-exempt and what it means to be exempt today. That's really the core focus of our discussion. Under the FLSA, overtime pay is required for hours worked over 40 in a work week. So it's important to understand what it means to be a work week. A work week is defined as any fixed and regular recurring period of 168 hours, which is 7 consecutive 24-hour periods. The work week does not need to align with a calendar week, and it can begin on any day and at any hour that the employer chooses. So the employer gets to decide. The employer gets to establish what the work week is. But it's important that the employer is consistent. So most employers will define this work week in their employee handbook. Remember, overtime is calculated based on a regular rate, which is not less than 1 1/2 times the employee's regular rate. So it's not calculated based on the hourly rate. And so this is an important distinction that we're going to talk about today. Regular rate of pay is the key here, and it's a common mistake. When I help clients with Department of Labor investigations, this is one of the issues that the investigator will probe and will really focus on. So the regular rate of pay, again, it's not the hourly rate, it is the hourly rate, but it also includes remuneration for any remuneration for employment, which would include non-discretionary bonuses or commissions if the employee is not exempt. It does not include a true gift. So if the employer gives, a Thanksgiving turkey or a Christmas bonus that the employer is not obligated to gift, it wouldn't include that. It doesn't include vacation pay. It doesn't include discretionary bonuses. So those are some things to think about when you have hourly non-exempt employees. It's also important to think about, and we'll talk about this a little bit later, to remember that state laws come into play here. So some states have overtime laws that are more stringent than the federal Fair Labor Standards Act. And if that is the case in a state where you have employees, and we know, with the change after COVID and with so much remote work, we're all looking at ensuring that we're complying in not only the state where our employer is headquartered, but in other states as well. So if you have employees in states that have laws that relate to wage and hour that are more stringent than the Fair Labor Standards Act, you need to also consider those. So let's talk about exempt status. Certain employees are exempt from overtime under the Fair Labor Standards Act, and these exemptions are generally based on the type of work and the employee's compensation. So there are two elements to it. So it's not just that they're paid on a salary basis, but they're paid on a salary basis and they meet a duties test. So to qualify for the exemption, employees generally must meet these two tests. The most common exemptions that employers will deal with are what we call the white collar exemptions. And those are the executive, the administrative, the professional, and the outside sales, but also certain computer employee exemptions. So those are the white collar exemptions. There is also an exemption that every employer should be aware of, and it's called the highly compensated employee exemption. So we're going to talk about those today, as well as how the change in the salary basis impacts those exemptions. So in order to do that, let's talk about the difference between what it means to be paid by salary and what it means to be paid hourly. A common misconception that many employers have is that if they pay employees on a salary basis, those employees are exempt. So paying an employee a salary alone does not make an employee exempt. But employers can choose to pay non-exempt employees on a salary basis. So I want to talk with you all about that today and make that distinction clear. When a non-exempt employee is paid a salary, it is typically for a set number of hours each week. But if the employee works more than that standard 40-hour work week, the employer must still calculate overtime. So to calculate that overtime for a salaried, non-exempt employee, the employer must first determine an hourly rate. That's the first part, but not the end of the inquiry. So this could be done by dividing the salary by the number of hours the salary is intended to cover. So for example, if a non-exempt employee is paid a weekly salary of $800 for a 40-hour work week, the hourly rate would be $20. If the employee works more, works a 20 or a 45-hour work week instead, the employer owes the employee additional 5 hours of overtime pay at a rate of $30 an hour. So that's 1.5 times the regular rate of pay. If the employee, however, works less than the expected 40 hours, the employer would be obligated by the agreement between the parties to pay the employee the full salary. So if you choose to enter into a salaried arrangement with a non-exempt employee, we need to think about these things. And we'll talk about it in the context a little bit later of how employers are going to deal with issues that come up as a result of the change by the new rule. So let's move on and talk a little bit about the salary basis for a moment. So being paid on a salary basis means that an employee regularly receives a predetermined amount of compensation each pay period on a weekly basis or less frequently. This predetermined amount, this is really the key to the salary basis, and it's what you need to meet that test if you're looking to have an exempt position. The predetermined amount cannot be reduced because of variations in the quality or the quantity of the employee's work. So that's really important. If those two things don't happen, if in fact that salary is reduced because the employee doesn't work the full amount of time or the employee does not perform well, then the employee is likely converted to a non-exempt classification. And so we don't want that to happen. So let me give you an example. If the employee misses a day of work, it's certainly appropriate for the employer to deduct from the employee's PTO bank, vacation bank, sick leave bank, according to your policies. But sometimes those employees don't have any PTO, vacation, or sick leave. And if they work any part of that work week, in order to remain exempt, they have to be paid their entire salary. So we'll talk a little bit about that as we move on. I want to talk with you a little bit about where we were and where we're going so you can see the difference. So before July 1st, 2024, and that's the first date we're going to talk about in a minute, the threshold for exempt status under these white collar exemptions for the salary basis was $684 per week. And so that equates to a $35,568 per year. That salary threshold for, when we talk about the rationale for an exempt position is typically a position where employees work at a higher level, they're expected to perform at a different level, they're expected to contribute more than others. That's a pretty low salary basis. For a highly compensated employee, and we'll talk a little bit about what that means, the threshold was $107,432. So let's talk a little bit about the specific exemptions so that you can understand where we need to see the threshold test and where we don't. So let's move on to the next slide. So specific exemptions, again, we talked about what these white collar exemptions were, and I want to make sure that we all understand how the salary basis really fits into each one. So the executive exemption includes the salary basis. So we've talked about what it is pre-July 1st, 2024. We're going to share with you information about what it is today after July 1st, 2024, what it will be beginning in 2025, and how it will escalate in the future. So for the executive exemption, you've got to meet that salary basis, and the threshold will apply, and then you have to meet the duties test. So for an administrative professional, you also have to meet that salary basis, so the threshold will apply, and a duties test. For a professional, when you look at that exemption, you have to meet the salary basis or a fee basis, which means that someone's being paid a fee for a project, and the threshold will apply. Now remember, there are two types of professionals. You can have a learned professional, which would include jobs like doctors and accountants. You could have a creative professional, which includes positions that may be in the theater industry or the arts. But there are exemptions for certain other types of professionals, lawyers, doctors, and teachers. And then we have the computer professional. So the salary threshold applies to a weekly amount, but not if the professional is compensated at an hourly rate greater than $27.63 per hour. So in those cases, the change in the threshold will not apply. In addition, we have outside sales. They have a salary basis and the threshold will not apply. So we'll talk a little bit about that as we go through our presentation today. So let's talk about one more category of exemption, the highly compensated employee exemption. And this again deals with both the duties test and the salary basis test. But it's handled a little bit differently for this group. So the compensation threshold, let's talk about that first, the salary basis. The employee must earn a total annual compensation that exceeds a specific threshold. So when we look at where we've been before July 1st, 2024, the threshold was, as I said, $107,432 per year. The difference here is that this amount can include all forms of wages. It can include their salary, but it also can include commissions, bonuses, and non-discretionary earnings. So that's really the key to the salary basis for the highly compensated employee exemption. Now, there is one other difference, and that is there is a slight different duties requirement. So as we've talked about, every time we look at whether or not an employee in a particular position is exempt, we are going to look at both the salary basis, which is what is changing, but we're also going to look at the duties test to make sure that they qualify based on the duty. And I'll tell you, before the change in salary basis, because the salary basis was so low, all of our cases really focused on the duties test. So it's important to understand the duties tests. For the highly compensated employee, the primary duty requirement is that the employee perform office or non-manual work. And that is a duties test for nearly all of these exemptions. But there's a little bit of a difference in the highly compensated employee because they only have to perform one or more duties of the executive, administrative, or professional exemptions. So as long as they perform one of these duties and they meet the higher salary basis, they can be exempt. So let's dig into that a little bit and talk about some quirks for the highly compensated employee. Employers can use a non-discretionary bonus and incentives, including commissions, paid at least annually to satisfy up to 10% of the salary threshold for this highly compensated employee. And this is a topic that we get a lot in Department of Labor investigations because it's a little more difficult to understand for employers, and often employers don't calculate that highly compensated threshold correctly, and the number's going up. So we have less wiggle room. We have to make sure we do it correctly. If an employee does not work the full 52 weeks of the year, for example, if they're hired halfway into the year or they are terminated or resigned before the end of the year, the salary threshold is met if the pro rata amount is paid to the employee. if the sum of the weekly salary plus that non-discretionary bonus or incentive, many times it's commission, but it could be other kinds of targets, is less than the salary threshold, then the employers have an opportunity to catch up. But the timing here is important. The employers have the ability to catch up in the very next pay period after the end of the year, a 52-week period. It doesn't have to be a calendar year. It can be your fiscal year, how you determine bonuses or commissions or incentives. In addition, if the employee resigns or is terminated and the employer has not yet met that elevated threshold for the highly compensated employee, the employer can catch up in the very next pay period after the end of employment. So the message here really is that an employer can fix it, but it must be done immediately. So it's not a situation where the employee leaves, the employee brings a claim, and 6 months down the road, there's litigation, and the employer is able to fix it. It has to be done immediately. So now, let's talk a little bit, now that we have those basics under our belt, let's talk about the changes. What's new under the Fair Labor Standards Act, and what salary threshold changes have been made under the new rule. So let's go to the final rule. So the rule is not long, but it has a lot of explanation. It spans only 3 printed pages, but it includes a lofty 128 pages of explanation. The first date to remember, and you probably all are already on top of this, is that the rule became effective July 1st, 2024. So you've probably been operating under the first $10,000 change already. But what we're doing today is we're preparing for the next change, which will be January 1st, 2025. And then we want to make sure that everybody understands what's happening in the future. And so into the future, the next scheduled 3-year updates will begin on July 1st, 2027. So let's get you ready for that. And let's move on to the next slide. So the new rule and the timing. As we just talked about, under the change July 1st, 2024, the thresholds have increased. So for these white collar exemptions that we talked about, executive, administration, professional, computer, outside sales, the number has gone up. It's now a $844 per week threshold, which equates to $43,888 per year. Remember, we were just operating under that $684 per week, or the basically $35,500 per year. So we're going up $7,000 or $8,000, and we want to make sure that we've made that change already and we're operating correctly under those parameters. The highly compensated employee threshold that we've been talking about has also increased. So instead of that $107,000, we're up to $132,964 annually. We talked about the fact that some of that can be commissions and can be incentive bonus, but it's important to remember that now that the threshold has increased, at least $844 per week, or $43,888 per year, must be on a salary or fee basis. So that has to be over the period. And there's some strategy to dealing with that. Many times, that fits into folks that do some kind of sales or commission, but don't meet the outside sales test for some reason or another. The other thing we want to do today is prepare you for that January 1st, 2025 date, and it is not far away. We are several months away from that, and the basis is going to increase again. So we're going to move from what we just talked about up to $1,128 per week for those white collar exemptions. And that increases that group of employees to at least $58,656 per year. That's a big jump from what we had just 6 months ago. It's not quite double, but it's almost double. And so preparing for this next change may be something you need to think about even more than we've been thinking about the first change. So again, the highly compensated employee number also changes, and it jumps up $50,000 in the 6-month period. So those folks, if you have anybody classified as a highly compensated employee to be exempt, they now have to make that annual number of $151,164. As we just talked about, of the $151,000, at least that new basis, $1,128 per week, needs to be paid on a salary basis. So about $58,000, $59,000 needs to be paid on a salary basis. The rest can be incentive, can be commission. So these are substantial increases. In addition to setting these new thresholds, the 2024 final rule provides a schedule for automatic increases. So let's talk about that schedule for a moment. The first such increase is scheduled for July 1, 2027. So as you're making decisions about how you're going to handle the changes in the final rule, you know, we need to really be thinking into the future about whether it's time for a reclassification or whether you're going to meet the increase in salary threshold demand. So that July 1st, 2027 change will be followed by subsequent increases, which will occur every 3 years. So if you know the history of the Fair Labor Standards Act, the reason the threshold is rather low at this point is that there wasn't an escalator in the law. This new rule is attempting to change that, or has changed that. These increases will be based on the then current earnings data, and the Department of Labor is going to announce the new number 150 days in advance of the notice. So these automatic increases weren't included in the previous 2019 final rule, but the DOL made a change in the 2024 final rule included in this supplementary information and is adopting this automatic increase. So we're going to talk in a minute about the challenges to the rule, and this is one of the areas that is subject to challenge. Let's move on to the next and talk a little bit about, we've talked about what's changed, let's talk about what hasn't changed. And this is why we reviewed a lot of the information related to what we've done in the past with respect to the Fair Labor Standards Act. So what hasn't changed? There are no changes to the duties test. So as we talked about, you know, salary doesn't get you to exempt. It has to be salary plus the duties test. Those duties tests have not changed. And so reviewing those and ensuring that your positions are actually performing the duties that they were assigned to perform is important. I'll talk a little bit about that. Job descriptions are a great way to manage that. Job descriptions and titles are not determinative in evidencing what the actual employee does. What I recommend to clients is when you do your annual reviews with employees, performance reviews, include in that the job description and ask the employee to re-sign it, confirm this is an accurate description of their job. What we see is where there are challenges to exempt status, employees, after they've been terminated or after they've quit, will often say, that was my job description, that's not what I did. What I did was this. I filed, I did menial tasks that weren't reflected in the job description. So if you have a position that may be on the borderline for a duties test, I recommend you do that. There really are no changes to how the salary basis is evaluated. So the number has changed, but the fact that the test is administered the same way, you still have to make sure that the employee's salary is not reduced based on quality or quantity of work. That hasn't changed. There has been no changes to the method of calculating overtime. So we went through that. Regular rate of pay, that's all the same. There are no new examples of exempt work. Again, that goes back to the duties test. All of those things remain the same. And so there aren't limits on the amount of work that an exempt employee can perform under the Fair Labor Standards Act. So employees can work more than 40 hours, obviously, during the work week, but they have to be paid overtime for all hours over 40. And then the Motor Carrier Act exemption hasn't changed at all. That's one we get questions about all the time. So while the number that a position has to pay to become exempt, one of the factors, while that has changed, the other elements of the test have not changed, and that's why we went through them at the beginning. So let's talk about what you can take away from this presentation, what you can implement in your daily work tomorrow. So by now, most employers have identified employees, because this started July 1st, who are either impacted by the July change or will be impacted by the January 2025 change. If you haven't done that, I encourage you to do that today. There are some opportunities here. We'll talk about it, about how you can address employees and this issue. You definitely want to be in front of it. For those employees who are currently classified as exempt and their salary is either right at, almost just a little bit over, or maybe a tiny bit under the new threshold or the January threshold, let's talk about what options an employer might have. And there are a number of different options. And so you're going to want to work through this by category of employee, and it'll give you an opportunity also to look at those who, to make sure they're all classified similarly. So first, if you're really close to the threshold level, you might consider just raising their salary to continue to ensure that they're exempt. Again, I would take the opportunity to review and make sure they meet the duties test. But typically, when an employee meets the duties test and earns a salary that is close to that new threshold, increase in the salary is the best option. You do that, you continue to classify them as exempt, business as usual. When we get to January, it's a $23,000 increase in that threshold, and it's not quite double, but it's a good amount above that. So increase in the threshold is not going to be an option for every position, for every category, for every employer. So in that case, the employer should really focus on reclassifying employees as non-exempt. And so there are a couple of options that employers can look at when they do that. The first is, and the one everybody always thinks about, is the employee can be paid on an hourly basis. And so some employers will look at the salary that they've been paying, and if they've been paying employees for 40 hours a week, and if the employee regularly works that amount of time, they might just take the salary, divide it by 40, and that will be the new hourly rate. They pay them on an hourly basis. If the employee doesn't work, they don't pay them. If the employee works overtime, they do pay them. But employers should think about how overtime is going to impact their budget if they do that. The other thing to think about is another option, and it is a salaried, non-exempt employee. So I have a number of employer clients who are interested in this. They ask questions about it, and I share with them all of the information. My sense, and there's a lot of good reasons to do it, my sense is that the employee gets the benefit out of the salaried, non-exempt employee under every scenario. But some employers really want to do it because it's really got a good morale impact to it. The employee, if they work more than 40 hours in a work week, they're entitled to overtime. And you're going to calculate that based on the regular rate of pay and how many hours are over 40 in that work week that you've defined. If the employee, however, works less than 40 hours, we've got to talk about how that's going to be handled. If the employee takes time off because they're on vacation or they have sick leave, you can use your policies. You can deduct it according to the company's policies. But if the employee has exhausted sick leave, has exhausted PTO, has no vacation, and the employee works any part of that work week, the employer has committed to a salary and the employer has to pay for that entire work week. Now, employers can deal with that issue through their conduct policy or their discipline policy. And so we just want to make sure that if the employee has a medical condition or would be covered under the FMLA or the ADA, you're considering that. So there are two options there about how to handle employees that need to be reclassified as non-exempt if they don't meet the new salary basis. When employees are reclassified, there are more issues to think about. If they're reclassified as non-exempt, whether they're hourly or salary, we have to think about the budget issues and whether there'll be additional overtime. To meet their budget needs, employers of non-exempt employees can certainly cut hours to make sure that overtime doesn't occur, monitor hours to make sure that overtime doesn't occur, cut other positions or hours to meet the budget. It's important to remember that if the employee is not authorized to work overtime but works overtime, they must be paid under the Fair Labor Standards Act. However, if the employee has worked without authorization, then they can be disciplined. So the other strategy that some employers have taken is to think about how much the employee who has been salaried actually works. And so if they don't work 40 hours, you don't have to set their hourly rate based on 40 hours. If they regularly work 50 hours as an exempt employee, you can set their hourly rate, understanding how that impacts your budget, and calculate an hourly rate based on 50 hours with 10 hours being at 1.5 times, and set the expectation with the employee that they're going to continue to work 50 hours. That is not a problem under the Fair Labor Standards Act. That's not a problem under the law. Sometimes that is a difficult message to send. So one other thing that employers often ask is, do I have to treat, so say I have 4 categories of employees who have different jobs, who may have fit under different exemptions in the past. If I say one group is going to be, I'm going to increase their salary. Do I have to do that for everybody? Another group, I'm going to make them a non-exempt. Do I have to do that for everybody? So this is a strategy that you should think about carefully and think about with respect to all of the actions you're going to take as a result of this rule change. So within a group, I do not recommend that you select, some employees to be increased to meet the salary basis and others to become non-exempt. So I would look at it from a categorical standpoint and suggest to you that you make a plan by category. But let's talk a little bit about how we might do that. Well, and before we get to that, let me just talk with you a little bit about state overtime rules, and then I'm going to give you some advice about how to really dig into these questions that are hard when you have a large group. So when you're doing your overall planning, it's important for you to consider state overtime rules as well. Years ago, the federal law was the most stringent law, and we can move to the next slide. The federal law was the most stringent law for wage and hour issues. That has changed over the last 5 to 7 years. So whenever you are considering wage and hour issues, you also have to make sure you understand where your employees are working. And it's also changed as a result of folks moving to other states but working remotely. So for Virginia, Maryland, and DC, those states, and Virginia has changed back and forth over the last several years, incorporate the federal standards for white collar exemptions. So if you have employees in those states, considering the federal law, you're going to be in compliance, Virginia, Maryland, and DC. For example, in other states like New York or California, they have a higher salary basis in New York. California requires overtime after 8 hours in a workday, unlike Virginia, Maryland, and DC. So just make sure that you are considering those things. And then I want you to think about, back to our question about when we're making these decisions for groups, you really do have to consider an equal employment opportunity analysis when you make the decisions if you've got a large number of folks and you want to make different decisions based on different categories. So again, within the categories, all the employees should either increase to meet the threshold or be reclassified as non-exempt. But where you have differing categories, conduct that EEO analysis and ensure that no unintentional pattern exists based on protected classes. So for example, I'll typically work with clients to prepare a spreadsheet of the employees in each category and their protected classes so we can evaluate and discuss whether there's any non-discriminatory rationale for each decision. So it may be that you have one class that's very close to the threshold and it's easy to bump them up and continue, and they work more than 40 hours a week. Good plan to make them exempt and continue that. You might have another group where they are further away from the threshold and they routinely work less than 40 hours a week, and so it doesn't make as much sense. Unless one category is all of the employees in that work group are of a protected class and there might be some kind of pattern, that would be a safe decision to make. But you just want to understand your workforce and what the issues might be before you make those decisions. Something that employers don't often consider is really a morale issue. Many employees believe that a salary carries a certain status within their work. Some employees think, I would love to be hourly because I want to be paid for every hour I work. But I have had many employers decide to make a group salaried non-exempt for just that reason. They feel like there is a morale issue, and they want to make sure that their employees feel valued and it's worth it to them. So something to consider. And then let's talk a little bit about administration. Where employers reclassify employees as non-exempt, the Fair Labor Standards Act certainly requires that employees and employers maintain a record of all hours that employees work. So you may have had a group that was exempt and they didn't record their hours, and now you've got to make that transition, and it's a very important transition. When we litigate these cases, employees who have not, they're alleging that they've been misclassified. So they are classified as exempt. They're alleging they should be non-exempt, and they are saying, I worked 80 hours a week, and the employer believes they worked 30 hours a week. And so it is the employer's obligation to keep those records. Where the employer does not keep those records, courts routinely allow employees to give oral testimony that they worked 80 hours a week, and they will accept that testimony. So it is really important, as these folks are being reclassified as non-exempt, that you get into place updates to your timekeeping system, updates to your policies, and that you train the employees about how to record their time. Employees don't like to record their time, but it's something we have to do. So the final point is to plan for appropriate messaging for pay changes. I always recommend that employers, when they make these changes, have a script, and also think about the questions that employees may ask so that they can have prepared answers. Let's move to the next slide, talk a little bit about opportunities. When employers regularly do find that they have misclassified a group of employees. It's not uncommon. And then the messaging can be difficult in that situation. Often employers will discover this error and then worry about the change highlighting a potential claim for a large group of employees. So the change in the law can be an opportunity. So if you have reviewed some of these issues based on the change in law and determined that you have groups that are not classified correctly or wouldn't be classified correctly under the new law, it's a great time to make the change. And the talking points are the law has changed, so we're complying with the law. And that is a very easy transition for an employer to make. And instead of the employee being disappointed in decisions made by an employer, the law is the reason for the change. So it may be an opportunity to, certainly everybody should be auditing their classifications now if they haven't already. And if they need to make a change, now is the time. So those are our plans going forward, but let's talk about there's litigation happening, and your guess is as good as mine. We've had this litigation before. The last change in the FLSA was a huge jump, and so now they've attempted to make it in steps, but there still is litigation. So let me chat with you a little bit about what the litigation shows. We know where we stand today. Let's talk about what might happen tomorrow, so you'll be up to date, and make sure you stay tuned to find out about any changes. So I want to talk about two cases that are dealing exactly with this new rule. The first is the state of Texas versus the Department of Labor, the DOL, and that was filed very shortly after the rule became final. In that case, the plaintiff argued that the Department of Labor doesn't have any authority to impose a salary level requirement. In other words, that the statute itself, so these are regulations of the Department of Labor, and you all may have heard about the Supreme Court decision in Chevron. That case deals with the authority of these agencies to make these rules. So that case will also become involved in this. But in the Texas case, a preliminary injunction has been issued by the court to block the rule. This preliminary injunction is only limited to the state of Texas because that's how the case was brought. So it's not a nationwide injunction. But we have this one case where the court has said that the rule is improper and it's been enjoined. Now let me tell you about a second case. So the second case is Mayfield versus the Department of Labor. And in that case, the plaintiff argues exactly the same thing. The plaintiff says that the Department of Labor has no authority to impose any salary level requirement. Different than the case we just talked about, the court in that case has said that the Department of Labor does have the authority. That case is on appeal to the Fifth Circuit and it's pending. And actually, I think they're having an oral argument tomorrow. So definitely stay tuned to see what is happening. It's possible that the Fifth Circuit might invalidate any salary basis requirement. And if so, it could jeopardize the rule for employers. If it upholds that decision, then we're going to have these two cases that are saying exactly the opposite. And that, I think, will lead to ultimately a case in the Supreme Court, and the Supreme Court will rule on this. But as it stands today, the rule is effective. And all of our employers should be preparing, as we've discussed today, for the increase in January. So that's what I have for you today. I'm happy to take a few questions. And so let's start with the first question I have is, are the thresholds calculated on a full-time equivalent basis for purposes of part-time personnel? Okay, so we talked about these thresholds and we talked about the fact that they apply to exempt employees. So part-time employees certainly can be exempt under the Fair Labor Standards Act. You know, if they're truly part-time and they're not working 40 hours a work week, we don't deal with it very often. But for these part-time employees, the salary basis still applies. Those bases for part-time employees are not prorated. So if you have somebody that works 50% of the time, you can't pay them 50% of the salary basis, wherever we are on that, in order for them to be exempt. So they have to be paid the full amount of the salary basis in order to be qualified as exempt. And so that happens often with higher level employees, accountants that want to work part-time, that kind of thing. So we do see that often. And then while they don't often work more than 40 hours because they are part-time, they might go to a conference or it might be tax season. And so they do often fit into the exempt status, and you'd want them to be exempt so that you don't pay them time and a half when they work that long week. Okay, let's do a couple more questions. I know we're getting to the end of our hour. The next question is, do the increases impact the outside sales exemption? So this is a good question, and I hope that I was clear in the information I was providing. So no, the 2024 final rule does not impact the outside sales exemption. So they are not subject to the salary threshold. And certainly it also doesn't impact the existing duties tests for those white collar exemptions. So remember that the duties tests were not changed, and because outside sales is not subject to the salary basis. There's no change from the 2024 final rule on that. Okay. So I will read, this is a long question. So here's the question, we'll do our best. As of 8/6/24, an employee is currently noted as exempt on job description and is paid a fixed salary each pay period and is listed as executive, and the company defines a work week as 37.5 hours, but makes less than 132.9. What should happen? Okay, so this has a lot of questions in it. So if they're exempt under the executive exemption, then they have to meet both the salary basis test and the duties test. So the salary basis test is not that 132. This would be under the exempt employee exemption. And so that is based on whether we're talking about it currently or whether we're talking about it in January. It's either the 43,000 or the 58. Is that what we're 53 or 58? 58. So they have to meet that salary basis. Then for the exempt employee exemption, they have to have a job which requires judgment and discretion. This is the duties test. And also oversee, hire, fire 2 or more full-time employees, FTEs. That full-time employee level can include part-time employees that aggregate to be 2 or more full-time employees. So if those two tests are met, the duties and the salary basis, then the employee would be exempt. So the question a little bit combines both the highly compensated and the exempt and the executive exemption. So to make the higher number, if they're exempt under the executive employee exemption, that's the end of the inquiry. They're exempt. They continue to work as many hours for that amount of money. If they don't meet that duties test, then there's another opportunity to look at the highly compensated exemption. And if they meet that number, they only have to meet one of the duties tests, and it can be of the executive, of the administrative, of the professional, or one of the other white collar exemptions. Yeah, so we'll do this last question because I know it's time to go. The question is it okay to set a company policy to not hire from certain states with more onerous employment laws as long as it is consistent? Do not hire from Maryland. Yes, so employers can choose, what you can't make employment decisions based on a protected class, but if you only operate in certain states, you can certainly only seek candidates from certain states, and that is very typical. Again, you want to be sure that you don't seek from all the different states and then say, okay, we're not going to pick from this state, and this state. And those folks being of certain protected classes, that would create that pattern that would be difficult to defend. But perfectly, if you're only licensed to operate in Virginia, you can only seek candidates from Virginia. That would be perfectly appropriate. If you're only licensed to operate in DC, that would also be appropriate. Okay, one last question. This is a good one. And then we will be done. The last question is, do you recommend exempt employees use a time clock? So this is a great question. I get it all the time. And certainly exempt employees are not required to record their time, but there are many good reasons to require everybody to record their time. If you have a project management or client building requirement, that makes sense. If you want to know about attendance and schedule management, that makes sense. If you want to use that time for performance evaluation, that makes sense. So the only, I hear this all the time because employees will tell HR or employers, I'm exempt, I don't have to record my time. The employer can always require it, and there are good reasons for it. Some of the cons of that might be employee morale or administrative burden, but yes, employers can always require anybody, exempt or non-exempt. Non-exempt they have to, but exempt or non-exempt to record their time. Not a problem. Okay, so we've been through the questions. I appreciate all your time. I'm gonna hand it back to Elena, and thank you so much.
Thank you, Betsy, and thank you everyone for attending today's webinar. Reminder that you will receive a follow-up email within 24 to 48 hours with a link to view a recording of today's webinar, as well as a copy of the slides. On behalf of Whiteford and our presenter, thank you for joining us and have a great rest of your day.